Thank you, Mr. Speaker. Great to be up on my feet to talk about Bill C-15, and I'll let you know that I'll be splitting my time with the member for Windsor West today. So, Mr. Speaker, my colleagues and I stand in support of this Act at third reading, and you may recall that you actually stood and I spoke on the bill at second reading in opposition to the bill. My colleagues on the Defense Committee, and I applaud their great efforts, and others in the House today have also applauded their efforts, put forward 22 amendments and 5 sub-amendments and made a great effort, Mr. Speaker, to change the bill at committee, none of which has also been pointed out today were successful, but the bill was amended at committee. Conservatives seem to have seen fit to amend their own mistakes, which is always helpful. That isn't to say, of course, Mr. Speaker, that we support this bill wholeheartedly. It is somewhat reluctantly that we do so. And I want to comment on this issue for a moment because it's been the subject of much debate. And it's a bit tricky, of course, Mr. Speaker, to be supporting a government bill at third reading. And we heard the Minister for Defense waxing philosophical earlier today about not letting perfection get in the way of progress. On the other hand, we heard the Liberal defense critic express his confusion and uncertainty about why the NDP would be supporting this bill. How could the NDP be supporting this bill? And the challenge is, I think, more difficult than either of those extremes would suggest. It's not so much a philosophical matter, Mr. Speaker, but really very practical one. And justice systems, as informed as they are by theory and philosophy, have very real, profound, and practical implications for those who submit or are subjected to them. And this is the case, obviously, before us. And for reasons that we all seem to agree with, it's about balancing the need for quick, expeditious military justice against the need to keep discipline in the force, but provide fairness for members of the forces. We have consideration today of a very unique judicial system, military justice system, and its need for discipline. But we also need to take into consideration, Mr. Speaker, the issue of time. That has to weigh heavily on our considerations about whether to support this bill or not. For all the talk about their support for the military, the Liberals did nothing with their majority government to amend the Act in spite of having the report of a justice before them, making 88 recommendations. And the Conservatives have been in government now for 7 long years, Mr. Speaker, and similarly have opted to do nothing to this point. And it's because this bill has such a long history that we need to consider, Mr. Speaker, about what we can agree to, what we must agree to in order to make progress and move this forward. And I won't recite the full history. We've got no time for that today, Mr. Speaker. So let me give you a short summary to illustrate the point. The bill had its genesis in a 2003 report on the Canadian military justice system by the former Chief Justice of the Supreme Court, the Right Honourable Antonio Lemaire. And that report contained 88 recommendations for change, Mr. Speaker, and it's suggestive of some very significant deficiencies in the military justice system in Canada. The bill is also a legislative response to a 2009 report by the Standing Senate Committee on Legal and Constitutional Affairs dealing with these very same matters. And again, in December of 2011, yet another military justice report was presented to this government, this time by former Chief Justice of the Supreme Court, the Right Honourable Patrick Lesage. And I would note that this government sat on that report for a year or so before finally tabling it in June of 2012. And so to date, Mr. Speaker, we are at the point where only 28 of the recommendations from that original Lemaire report of 2003 have actually been implemented, and some in the form of legislation, some as regulations, and others as change in practice. We've even lost some ground, it needs to be noted. In the previous Parliament, Mr. Speaker, Bill C-41 died on the order paper, and it included important updates to the National Defense Act that are interestingly absent from the bill we're considering today. So the chains got moved back upfield, and that's disappointing. But I think the purpose of talking about the length of time, Mr. Speaker, that this government and the previous Liberal government have taken to bring some sense of fairness to the members of our armed forces with respect to their justice system means that we need to consider very seriously what we need to do now, because we don't know, Mr. Speaker, when we'll get our next opportunity to make change. And it is important that we make tangible change to this system, Mr. Speaker, so that it is a military justice system worthy of this country and worthy of the commitment that members of the Canadian Armed Forces make to this country. So as frustrating as all of that is, Mr. Speaker, we focus on the progress that's being made, and we see some progress. I shy away from calling it significant, but it comes in the form of greater flexibility, for example, for the sentencing process to more closely parallel the civil criminal justice system, provides for additional sentencing options, including absolute discharges, etc. It modifies the composition of a court-martial panel. It modifies the limitation period applicable to summary trials and allows an accused person to waive the limitation periods. And it clarifies the responsibilities of the Canadian Forces Provost Marshal. It also makes amendments to the delegation of the Chief of Defence's powers as the final authority in the grievance process. But above all of these changes, as tangible as they are, Mr. Speaker, one stands out as critically important and most certainly worthy of support. It's an issue that we in the NDP have pushed for many years, including in the previous Parliament, and actually had made some progress with in Bill C-41. And it is this issue more than any other that tips the balance in favor of supporting this bill. And it has to do with the number of offenses that can result in a criminal record. And the NDP, through the long history of this bill, has consistently pushed for the reduction in the number of these offenses. And with this amendment under C-15 emerging out of committee, it'll be the case that about 95% of cases will not attract a criminal record, Mr. Speaker. And in addition, that those who have been previously convicted of these offenses will have records expunged. And this is an important issue, Mr. Speaker, because many of the offenses that we have been focusing on do not generally have a civilian equivalent. They are, for example, offenses described in Section 85 of the Act, which involve threatening or insulting language or behavior contemptuous towards a superior officer. And Section 86 involves failing to stop someone from deserting, and Section 97 deals with drunkenness. And we've long considered it, Mr. Speaker, unjust, as have many other experts who have weighed in on this matter, that convictions of those kinds of offenses through this kind of summary trial process can result in criminal records that can follow members of the Canadian Armed Forces into their civilian life. Now, it's important to note that the summary trial, Mr. Speaker, is used to try about 95% of disciplinary cases in the forces, and it is this process that's used to effect the balance between the competing interests of discipline and returning a soldier to service. And as such, fairness and justice are compromised. And I'll give just quickly an example. A commanding officer or designated superior officer can act as the judge. There's no legal counsel or appeal or even a transcript of the file. And so we consider it unfair for criminal records to flow from and follow a soldier into civilian life from that. So we're pleased, Mr. Speaker, to see that amendment, and we'll be supporting this bill. Thank you.